This meeting is being recorded.
Good afternoon and welcome to the Relative Search Notice Engagement and Placement Consideration webinar. A couple quick things. Please stay on mute throughout the presentation. We have the chat enabled to put the questions in the chat there. We will answer kind of throughout in the chat as we are able, and also have a question and answer time at the end of the presentation. Slides will be available after the webinar, and we are recording this, and it will be available for future viewing on our FFPSA website and the Minnesota Child Welfare Training Academy website. So start quickly today with introductions of our presenters. My name is Jessica Broger, and I work in the Family Support and Placement Services Unit as a Child Placement Policy Specialist here at DHS. Joining me today, I have my coworker, Tendai Wojtak, Alicia Wolfman, who is a Permanency Quality Assurance Team Program Representative, and Ashley Holmes, who is joining us to talk about the ICPC, or the Interstate Compact for the Placement of Children. So today we're going to be looking broadly at relative search. This past legislative session, there was a policy bill that passed that strengthened relative search notice engagement and consideration from the point of an initial hold through permanency. We have incorporated changes and we'll be highlighting them throughout the presentation today. A quick note, we often use relative search as shorthand for a process that includes the search or identification, notice, engagement, and placement consideration. We're going to try to clarify by using the term search broadly and identification as the first step of that search and engagement process. So our objectives today we have here on the screen, and really looking at how relative searches are critical to support family towards reunification, and really thinking through that with children, parents, and tribes. And then the search steps and requirements to improve and enhance practice, of which is going to be of interest, of course, to social service agency staff, county attorneys, parent and child attorneys, guardians ad litem, and judges, and then the judicial review requirements. So why are relative search required? We're going to start with some of the foundations of relative search efforts. So first off, talking about Minnesota law recognizes the importance of relatives and relative connections in the lives of their children. The federal law focuses specifically on a placement preference. We're going to talk much more broadly about engagement and other ways that relatives can contribute to care and planning of children. And the courts have the duty to ensure that child welfare agencies are using reasonable or active efforts when a child is an Indian child to prevent out-of-home placement, to reunite with family, and to finalize alternative placement plan when reunification is not an option. With that, I wanted to call out that while our focus today is on relative search, we do want to start with a reminder of the requirement of assessing a non-custodial parent, including an unadjudicated parent, for their ability to provide the day-to-day care. A parent does not have to meet foster care licensing requirements. Their standard is safety as a parent. So in those situations where a child is able to perhaps be placed immediately with a non-custodial parent, that really impacts the focus of relative engagement. So that's wanted to just situate that up front, as before we're looking at placing with relatives, for example, we should be first looking at engaging a non-custodial parent and assessing their ability to provide day-to-day care. And the search is for maternal and paternal relatives, including paternal relatives where paternity has not been adjudicated. One of the changes with the legislative session was that it requires the peace officers to notify not only the parent, but also a child of 10 or older, of the ability to request that the child be placed with a relative rather than in shelter care immediately, and for the peace officers to coordinate with local social service agencies when a relative is identified as a placement option and being taken into custody for their health or welfare being endangered. So overall, we just want to start with a little bit of vision casting and talking about kind of in the ideal world, children being more connected to and reliant upon their family relationships, culture, and community. And relative search really helps position the agency to connect the child to those family relationships, which in turn connects the child to their culture and community. And as I mentioned previously, we in the state of Minnesota want to focus not only on the federal requirement of placing a child with a relative when possible before considering placing with a non-relative, but also the many different ways that relatives can participate in care and planning. So there, with this past legislative session, that added additional ways of participating in care and planning. And it also bars limiting a relative's participation in care and planning based solely on their previous inconsistent or non-existent participation. So even if children aren't placed with them, relatives contribute to safety, permanency, and well-being in many ways. It can be through participating in case planning for the parent and child. And in addition to that is saying identifying services and resources to meet the individualized needs of child and parents, whether that's in person, via phone call, or by electronic means. The identifying strengths and needs of the child and parent, two other new ones kind of added, embedded in that, acting as a support person, asking to be considered for placement. We continue to have the supervised visits, provide respite and vacation visits for a child, provide transportation, suggesting other relatives who may be able to participate in care and planning for a child, and maintaining the child's regular and familiar activities in contact with friends and relatives, including providing supervision of the child at family gatherings and events. So really looking at, even if a child needs to be removed and placed in foster care, what are the opportunities to maintain connection, not just with parents and siblings, but their broader support system and family members. Additionally, due to the new requirements with FFPSA, we added participating in family and permanency team during a QRTP assessment if a child is being placed in a qualified residential treatment program. Consistent with that, in 2019, we released our EDOC 7830, which really talks about even when a child is in non-relative care, or whether in relative or non-relative care, looking at how can relatives be utilized for alternative care, whether that might be for daycare or respite, is working with family as much as possible and planning to ensure that kids have that regular contact and that they're looked to first, rather than looking at other non-relative homes as options to provide some of that care. Wanted to start with just the protective factors framework. It's a strength-based framework on aspects that shore up the safety of a child rather than a focus on fixing problems. Relative search fits within this framework by recognizing the importance of social connections and caring for children, and the support and thus protection that provides for parents and children. It's often said that people need people, and a relative search is an opportunity to help the family use their existing support network to support the child and the parents during this stressful time. So that, again, is reflected in that statutory requirement to engage relatives in participating in care and planning.
Hey.
I like to know what everybody's saying.
Someone mute the people who are speaking, please. Okay. And with that, I am going to transition over to Tendai for the next section.
All right, thank you, Jessica. So I'll be talking about just the key steps in the process of relative search. Next slide. So we wanted to start with just getting an understanding of what these key steps are. And the first step is really understanding the definition of who a relative is. I know everyone on this webinar is pretty familiar with this, but we just wanted to go through it because there is some legislative changes to the statute definition of relative. But as we're aware, for an Indian child, a relative means a person who is a member of the Indian child's family, and this is also as defined in the Indian Child Welfare Act of 1978. So ICWA really does state that an extended family member is defined by law or custom of the child's tribe, or in the absence of such a law, a person who has reached 18 and who is the Indian child's grandparent, an aunt, an uncle, brother, sister, brother-in-law, sister-in-law, niece, nephew, first or second or step parent, first, second cousin or step parent. Next slide. And the statute, the Minnesota statute defines relative as a person related to child by blood, marriage, or adoption, legal parent, guardian, custodian, or the child's siblings. And this includes guardians of adopted siblings as well. With the 2022 legislation, the definition was amended to add the information that's included and underlined on the slide here. So now it also includes an individual who is an important friend of the child or of the child's parent or custodian, including that same individual with whom the child has resided with or has had significant contact with the child or the child's parent or custodian as well. So this new information is also will be considered as part of who a relative is. With this new amendment, it's really just acknowledging that many people do consider close friends, religious advisors, or other individuals who they have significant relationships to be a part of their family, despite that not being, the legal, biological, or marital relative. So some examples of is close friends is can include, a godparent for an infant and who, by virtue of removal, did not have established relationship or clan relationships. So those are kind of examples of who can be part of who's considered a close friend, right? Also, the Minnesota definition for relative is broader than the federal definition, as it actually includes individuals often referred to in federal language as fictive kin. Next slide. So when is a relative search required? It will be required when a child enters foster care. So this includes the situations where a child enters placement and so if they go straight to grandma's home as an emergency placement, the agency is still required to conduct a relative search even in that kind of situation. Another time when it's relative search is required is when the child must be moved from a current foster setting. This would apply in those situations where there is placement disruptions. So relative search at that time must be revisited and updated when a child's placement is subject to change. Another time when it's required is when a child must be permanently placed away from the child's parents, and also when the child returns to foster care after permanency is achieved. A couple more places where relative search is required is when a child is under guardianship and does not have an adoptive home. So regardless of whether the court relieved the agency of relative search efforts or found that the agency made diligent efforts previously. So it will be required to do a relative search in that kind of situation. So this would be kind of those cases where a child's pre-adoptive placement is disrupted for any reason. Another time when relative search is required is voluntary placements under 260D. So residential placements were previously excluded from the requirement of relative search. However, due to the FFPSA requirements, a relative search is now required for the purposes of assembling the family and permanency team when a child is recommended for placement in a QRTP. And the family and permanency team is just part of the individuals who will be part of the assessment done by the qualified individual. And lastly here, a search is also required when the court determines an updated relative search is in the child's best interest. In those cases when a child is placed in foster care under the Safe Place for Newborn provisions, a relative search or relative placement preference is not required at that time, as long as the agency staff do not know the identity of the child, of the child's mother or father and child as well. So if the identity will apply. Next slide. So in this next slide, we'll just go through like just an overview of relative search requirements. So really, it's talking about the reasonable and active efforts, which must involve due diligence by the agency to conduct relative search, to identify and then provide notice to adult relatives. And with the 2022 legislative amendments, this now includes even current caregivers of a child's sibling. And these reasonable active efforts, either on relative search, either is done prior to child's placement or within 30 days after the child is removed from the parents. With the 2022 legislation as well, it also added that this also occurs regardless of whether a child is placed in a relative's home. So a relative search is required at that time as well. So the search includes getting information from the child in an age-appropriate manner as well about who the child considers to be family members or important friends with whom that child has resided or has had a significant contact with. The search includes maternal and paternal adult relatives of the child. So we're talking about adult grandparents, all legal parents, guardians, custodians of the child's siblings, and any other relatives suggested by the child and child's parents. With relative placement and continued contact with relatives does help the child maintain their cultural, ethnic, tribal, community and family identity and legacies, which are all vital components of the child's psychological development and emotional integrity. A decision by a relative not to be part of the potential permanent placement resource at the beginning of a case or beginning of a child being placed in foster care will not affect later considerations. Statute now clarifies that the agency may provide oral or written notice to a child's relative, and agencies are now required to document providing the required notice to each of the child's relatives in the child's case record. So documentation is not required of the notices that were sent out to each relative. So if a relative who may have forfeited the right to receive a notice by failing to provide like a current address to the agency or the courts, they may also begin receiving notice once they provide a current address to the agency and the courts. And the notice also is now explaining that regardless of that relative's response, the agency is required to establish permanency for the child. And if that particular relative does respond to the notice, they will receive information about participating in the child's family and permanency team should the child be placed in a QRTP certified facility. And Minnesota district courts required by law to review an agency efforts pertaining to relative search, notification, and engagement, and will determine whether due diligence standards have been satisfied. So the regularly scheduled hearings that are required under 260C-202 is where agency workers will continue to report to the court their efforts to identify maternal and paternal relatives, child and engage relatives in providing support for child and family. I want to make a quick note here before I move to the next slide. That is part of the 2022 legislative updates. Minnesota Statute 260C-221, which is the relative search statute, was reorganized with existing content and the new content we will be talking about throughout the presentation into 5 different subdivisions. So relative search requirements is its own subdivision, including relative notice requirements, relative engagement requirements, placement considerations, and then data disclosure and court review. Just want to make sure I mentioned that. Thank you. So as Jessica mentioned in the beginning, you're going to hear us talk about identify or search, notice, engagement, and consideration throughout the presentation. So here, engagement really includes considering the role of the relative in supporting the child and considering them for placement as well. So even if children are not going to be placed with a relative, these relatives can still contribute to the safety and well-being of children in many ways. So that's why it's always important to make sure that So searches are being done, notices are being sent, and engagement is being done as well. So the goal for agencies is then to always continue to identify and engage these relatives, even once placement has been determined. So it would be important to reconnect and follow up with all relatives, including those who might have said no initially to being a placement option or resource, as circumstances for those particular relatives might have changed. Engagement with relatives can be a meeting in person versus calls or letters. And the concept of due diligence and reasonable efforts are specifically used in statute to describe the agency's efforts towards a relative search, notification, consideration, and engagement process. And this requires this process to become, to be comprehensive in scope. So agencies will be required to detail what has been done to identify, provide notice, consider, and engage relatives. And this in turn really ensures that as many family members as possible have been identified, invited to participate in case planning for the child, and screened on safety issues to ultimately work together as a family to support the needs of the child to achieve permanency. Next slide. In this section here, we're just going to talk about who must be contacted as part of the relative search. So Minnesota statute requires the search to include maternal and paternal relatives, all adult grandparents, all legal parents, guardians, or custodians, caregivers of the child's siblings, any other adult relatives suggested by the child's parents, and that's really subject to the exceptions due to family violence. And you can see here Minnesota statute 260C 221. This was updated under subdivision 1. Next slide. Thank you. We're not going to go into too much detail about this section into the paternity specifics today, but we did want to include some examples you see here that sometimes get missed on who might be engaged as a father, as it matters to make sure that we are engaging the fathers, and that also in turn opens up engaging the paternal side of the child's family. So some of the examples of who should be engaged as far as a father is concerned includes any man who mother acknowledges could be the biological father, but even if she's not sure, a estranged husband who could not possibly be the biological father, any man who says he's the biological father of a child, even if mom denies, mother's current husband, who she's married shortly before the child's birth, mother's current boyfriend, or a man who mom was married to at the time of conception, but divorce is now final. So all these examples of who might be a father will be helpful in engaging those paternal relatives. So relative search for paternal relatives really hinges on identifying the possible fathers and ensuring that we are engaging those individuals. So agencies should concurrently work on this, as it would be in the best interest of the child as well. All right, we wanted to make sure we also share some questions that agency workers can ask parents when gathering information on possible relatives. And this includes, but it's not really limited to just these questions we have on the screen. So it would all pertain to, you know, the family that you're working with and the circumstances for that, and how you add more questions to this list. But we just wanted to give you guys a list of what these are. So things like, you know, if you cannot care for your child, who would you trust with their care? How big is the family? Who does the child live with when they're not at home with mom or dad or grandparents? Does the child have any siblings, including half siblings, even step siblings as well? Because those adult guardians of those half siblings or step siblings would be considered relatives as well. Does the child have significant relationships with any other family members? Does the child have any close friendships Does parent have any close friendships that they may have contact with? And how would the child describe relationship with these relatives? So, I mean, these questions can go on and on, as long as it's questions that provide information and clarity on being able to then identify possible relatives for that child or family. So even things like, you have any family reunions, who organizes them, who was at the recent family celebration, is there anyone not related by blood, marriage, or adoption that the parents or child consider to be family? So like I mentioned, these are just a few questions, but I'm sure they can vary as well depending on the family that you are working with. Next slide. And this slide is about engaging children. So as part of the relative search, Minnesota statute does require involving the child in the relative search process. And this includes being able to ask the child in an age-appropriate manner about who the child considers a relative and who they consider to be an important friend to them that they've either lived with and have had a significant contact with. It will be important to remember when we're engaging children that the child's developmental level should be considered as well during the larger search process to support this engagement. And this engagement of the child may also involve asking them about relatives by using thoughtful and probing questions. And a couple examples would be, where do you usually go for family gatherings? Do you call anyone granny, grandpa, nana, auntie, uncle, papa? You know, all those names that kids call their grandparents or aunts. Who helps you with things. Visuals that might be helpful in engaging children as well in relative search processes as such. Signs of safety like the 3 houses or eco maps. And these are just examples of what can be used. Identifying important friends. So as far as identifying these important friends of the child or the child's parents, who they have a significant relationship with, consider anyone who has called about the child, provided support for the family, attended a court hearing, visited the youth in any capacity, godparents, any close friends, anyone in the role of the child's teacher, counselor, special education professional, or coach, currently or previously. So all these collateral resources may wish to be a placement resource, placement and or permanency resource for a child, and may know of relatives not yet disclosed and any other persons who have demonstrated an ongoing commitment. And part of this too is that these people will also be part of the care and planning of the child as they are in a separate placement as well. Okay. Next slide. All right, so when parents object to a relative search, so if a parent will not provide the agency sufficient information to identify maternal and paternal relatives of the child, staff can ask the juvenile court to order the parent to provide the necessary information. And agency staff can also use other resources, social media, obituaries, LexisNexis, to identify some of the child's maternal and paternal relatives. If a parent makes an explicit request for the agency not to contact a specific relative due to safety reasons, staff can definitely bring this request to the attention of the court to determine if that parent's request will be consistent with the child's best interests. And safety reasons include things like past family or domestic violence and existing order of protection for past domestic child abuse findings, which must also be brought attention to the court. For any voluntary placement in a QRTP certified facility, that's a qualified residential treatment program, for purposes of engaging in this relative search, the staff must consult with the child's parent or legal guardian, and if the child is 14 as well or older, and if it applies, the child's tribe, to obtain recommendations regarding which adult relatives the agency should notify about being part of the family and permanency team for the purposes of being in placement in the QRTP certified facility. So if in this instance, if the child's parents or legal guardians raise concerns about specific relatives, agencies should not notify those relatives. In regards to children placed in a QRTP certified facility under 260D, since the parents and custodians are agreeing to a voluntary placement, this will really mean that they would be agreeing to their responsibility as part of that, which includes convening the family and permanency team for the purposes of completing the required QRTP assessment. If parents are unwilling to participate in their responsibility as agreed upon by the VPA, agencies may consider if the VPA is appropriate at that time. Also, in the 2022 legislation update, Minnesota Statute 60C221 was updated and now says that unless safe place for newborn applies to the child's case, a court shall not waive or relieve the responsible agency of reasonable efforts to conduct a search, notify relatives, contact and engage relatives in case planning, and consider these relatives for placement as well for the child. Next slide, thank you. So this next slide is really, as we have been discussing, the relative search components comprise of searching or identifying, notifying, engaging, and then placement consideration. All these pieces are really vital to making sure that children and their families stay connected. So when we talk about relieving efforts, we're really talking about that the search and identify. So when the court makes an order that an agency has satisfied the relative search, this does not mean the agency has been relieved of all efforts with a relative. So that's why we blacked out the first section there, which had identify and search. So this means really the agency is not required to continue to actively search for relatives. However, a relative who responds or becomes known later in the case will still need to be notified, engaged, and considered. Jessica briefly talked about participating in care and planning when a relative who responds to the notice not only has an opportunity to be a placement resource option, but also participate in the child's care and planning. So these are some examples that Jessica did mention earlier. So even when a relative is not placed, a child is not placed with a relative, the relative can still contribute to the safety, permanency, and well-being of that child. So a couple of things that were added to the examples of how a relative can participate in the care and planning in the new legislation was they can act as a support person, asked to be considered for placement, and participate in the family and permanency team during the QRTP assessment. So those were just the 3 additional ways to participate in care and planning. So some of the examples you can see here are, identifying strengths, supervise visits, provide respite and vacation visits for child, transportation. All those are still pretty much the same, including providing supervision of the child at family gatherings and events as well. I would like to also point out that the 2022 legislative session revised the statute, and these relative engagement requirements are now under their own subdivision, as I mentioned earlier. This bars limiting a relative's participation in the care and planning based solely on their previous inconsistent or non-existent participation. So if they didn't participate in the last case, it doesn't mean they can be excluded from this current case as well. All right, I'm going to throw it back to Jessica.
Thank you, Tendai. So I wanted to talk quickly about some questions to consider in practice, starting with with whom are we speaking, and ensuring that we're really making comprehensive efforts both with maternal and paternal families. We often find that maternal families are more thoroughly engaged and considered for placement, and a mother might prefer her family, but that doesn't automatically mean that her relatives are best able to meet the child's needs. When fathers aren't responding or providing information, there's still ways to find out information about possible relatives. An example that we talked about earlier is an option of like looking for obituaries if you know that grandma was the keeper of the information and had recently passed away, or knew that she had passed away previously, that we could look for her obituary and is likely to name aunties, uncles, siblings. And then we also wanted to talk a little bit about the values and experiences that people have had and how that might play into it, both personal or professional. One thing is, for example, there might be a background issue and it can't be licensed to be a foster parent, but they might be able to be part of the care and planning and have unsupervised visits, including overnight visits, if that's in the best interest of the child. Sometimes we hear people concerned that relatives are receiving public assistance to meet their own needs, and that's someone who is meeting their own needs through the use of things that they are eligible for. Certainly we have consultations when there's things around like clutter or space issues and bedrooms and storage, and some of that might be cultural around size of home or sharing room arrangements, and sometimes it can be a financial issue of being able to have a larger home that has more space for storage, or and there might be more things on the counter or in boxes on against walls, and those aren't safety issues. It might not be your personal preference, but it might be how that family is able to meet their needs. Another one that we hear a lot about would be single parents. So a worker might have a preference for a 2-parent family, believing that automatically means more support for a child, which may or may not be true. Or they might have been raised by a single parent or be raising children themselves as a single parent. And based on their own experience, they might view that either negatively or positively. So always kind of stepping back and realizing kind of what you're bringing to the table and how that might impact your assessment and whether or not that really is impacting decisions for this child. So did it flip to the next slide? Placement preferences and considerations. So overarching placement factors are on the screen, again, considering first the relatives by blood, marriage, or adoption before looking at people who would fall into that important friend or significant contact with either the child or their parent or guardian. As mentioned previously, for an Indian child, the ICWA or MIFPA placement preferences. We have the Sibling Bill of Rights, emergency placement versus a planned relative placement, and engaging a child or youth in the discussion, which I know Tendai talked about. So Minnesota law requires documentation of how both foster and adoptive placement decisions are made, and that is now added into 260C.221 subdivision 4C. And then requires an individualized determination of a child's needs and how the placement meets both their current and future needs. Is one of the things that has changed now, is that it's also recognizing that there might be some different needs in the future, and that needs to be carefully considered when we're looking at permanency as well. And then it provides guidance regarding that preferred order of placement with relatives. So with the individualized determination, the best interest factors, this is just kind of the high level functioning behaviors, medical needs, educational needs, developmental needs, history and past experience, remembering that we clarified that individualized determination includes current and future needs. And then we updated the language on relationships with parents, siblings, and relatives. And that agencies must not use one factor to the exclusion of all others, and consider that the factors may be interrelated. So the others that I didn't read off were the religious and cultural needs, connection with the community, school, and faith community, interests and talents, ICWA and MIFPA, reasonable preference of the child, and again, that current and long-term needs regarding relationships with parents, siblings, relatives, and other caretakers. So wanting to ensure that we're always looking at child-focused decisions, that we may have multiple relatives being considered, and that using those best interest factors to help keep those decisions focused on a child's needs rather than the relatives' wants, and helping to use the families to assist in making those placement decisions. Another reminder that paternity does not have to be established for an individual to be considered a relative. In some cases, it may be more essential to determine that before placement. Really want to highlight that it's not sibling placement at all costs, and it's not relative placement at all costs. it comes back to an individualized determination of what is in the child's best interests. And that may end up being different for different siblings. So 3 quick examples. You might have siblings that have been split among relatives in foster placement. Individual relatives might be doing a great job of meeting complex needs, and the risk of placing siblings together might outweigh the benefit of maintaining the stability and attachment in a current placement. And where if they were all placed together, the caretaker might be overwhelmed by a level of needs in providing for all siblings together. With a thoughtful contact agreement, it might be in a child's best interest to maintain in separate placements. And then the next 2 examples kind of can be interrelated. So there might be one where like a grandma has been a primary caregiver for much of a child's life, and now the child has a younger sibling, but grandma's not feeling like she can meet the needs of a younger child. So it might be in the older child's best interest to be with grandma, while the younger child might be placed somewhere else. And then on the other hand, we might have a relative who is able to care for one child, but not all siblings together. And it might be in the children's best interest to be placed together, including if that might mean that they're all placed together in a non-relative home. So as you notice in those last 2 examples, that could be the same sibling group. And it really comes down to a thoughtful assessment and consideration of each child's individualized needs. So keeping in mind, it's not necessarily the first relative who says yes. Similar to how children are placed in a non-relative foster home in an emergency, a relative can also serve as a shelter home either because they can't commit to longer term, or even if they are able to, another relative might be better able to meet the child's needs ongoing. And then it's not necessarily who the parent wants. So there is, the preference of a child is a best interest factor. The preference of the parent is not. There is one exception in 260C.193 subdivision 3E. It talks about if the birth parent explicitly requests that a specific relative not be considered for the placement of the child, they need to honor that if it's consistent with the best interest of the child. And we talked about that in safety earlier. And it also says if the parent expresses a preference for placing a child in a foster or adoptive home of the same or similar religious background as that of the birth parent or parents, the court shall order placement of the child with an individual who meets that birth parent's religious preference. So I also want to just say, sometimes we hear, the language of moving a child as a ding for the Child and Family Service Review. And just a quick clarification, it's not if it's a planned move in furtherance of a child's best interests or permanency plan. So in order to have successful relative placement, you need to be thinking through what services are needed to support the initial placement, what supports will be used to care for the child. If that placement extends beyond an emergency stage, what supports or services are needed to maintain the placement? And again, what are those family strengths and protective factors? Placing with an unlicensed relative, the Minnesota Statute 260C.212 subdivision 2E allows for unlicensed relative placements when there is an emergency. What is an emergency is not defined, so we always recommend that placing agency staff consult with their county attorney regarding whether the particular circumstances at that time constitute an emergency and thus would qualify for a potential unlicensed emergency relative placement. It might be reasonable to consider the first 30 days an emergency while starting a comprehensive kinship search, including maternal and paternal relatives, and consider all relatives that are interested. So outside of emergencies, children should have a thoughtful transition from one licensed foster home to another licensed foster home. And then the emergency relative placement requirements, before or within 3 days, an initial inspection of the home. It is not expected that that home is going to, meet our safety checklist. In fact, I would be very surprised if any home did, because there's certain things on there like having a certain fire extinguisher, battery operated radio that a lot of homes may not have. We know that there may need some time to change some things or acquire some necessary items, and that is absolutely okay. There also needs to be the initial background check. And if there is a possible permanent bar or barrier crime that is identified, either for kind of the identified foster parents or parents in the home or any other household member, that placement cannot be made. That would not meet our emergency relative placement statute. So if a placement is made, then within 10 days, that family needs to submit the application and start the licensing process. And then I will turn it over to Alicia to talk a little bit more about that.
Thanks, Jessica. So like we talked about, background studies are part of the licensing process once that placement has been made. So it's important to know about disqualifications, permanent bars, and federal barrier crimes. Recently this year, we did have some changes to our foster care background studies where they align more with the federal background study requirements. We still have some disqualifications in addition to those federal requirements, but some of our previous bars were removed. If we are working with relatives or families that may have that disqualification, but do not have a permanent bar or a federal barrier crime, they may be able to get a variance and go through that process with licensing. It's not a guarantee that a variance may be granted. Hey, Jessica, can you go back a slide? Thanks. It's not a guarantee that the variance may be granted, but it is one step of the process in order for that family to move forward with the licensing process. Again, just reiterating, if there is a permanent bar, that emergency placement can't be made, and that there may be impacts for both placement and kinship and adoption assistance, depending. And permanent is permanent. Next slide, Jess. Moving into the permanent bars and barrier crimes, as it's specific to those permanency placements, if we are working with a relative with a permanent bar to foster care license, that relative may be able to get an adoption only home study for the purpose of adoption. The adoption placement agreement can be signed after the child is legally free and that home has an approved adoption only home study, including those required background studies. The child may not be placed in the home unless that family has, again, both that approved home study, including background studies, and the signed adoption placement agreement. If your agency determines that for permanency, that decision remains in the child's best interest, you're going to document why in the adoption placement decision summary. And again, North Star Adoption Assistance eligibility may be met. And again, with adoption placement agreements, DHS does review it placement. So that's why it's important that you are documenting why that placement remains in the child's best interest when they have a permanent bar. For federal barrier crimes, even if that family is able to get an approved home study, they will not qualify for North Star Adoption Assistance. And for North Star Kinship Assistance, exemptions are not granted for federal barrier crimes through the eligibility determination process. Kind of like what you heard us talking a lot today is getting people involved as part of these permanency discussions. It's important to include and get as many people kind of at the table and talking about what's in the child's best interest. We're talking about the 10 best interest factors and ICWA. We really want transparency and decision-making, so keeping relatives and people involved and communicating how decisions were made. We're also talking sometimes not only about legal permanency, but also relational permanency. And if certain relatives may not be able to be the legal permanency option, or even what the youth is wanting, how can we build relationships and get youth and children relational permanency as well? We wanted to put on here the permanency dispositions, and there has been a change to that. Obviously, we're always working towards reunification. And if that can't happen, looking at that non-custodial parent. If there's not the non-custodial parent, this is where the change is. So we're looking at adoption or a transfer of permanent legal and physical custody with a relative. Then if that, it's adoption by a non-relative. And then the last is permanent custody to the agency. And wanting to highlight that this is not a permanency disposition for children under guardianship. For adoption or TPLPC with a relative, although they are the same and we're looking at them the same in statute, for North Star kinship assistance eligibility, adoption will still need to be discussed and ruled out due to state and federal case plan requirements. So having that permanency conversation and talking about it at the same time with that relative about adoption or TPLPC, if it's determined that the TPLPC is in the best interest, you're documenting that you had that conversation about why adoption isn't in the child's best interest for kinship assistance eligibility. For notice of review hearings, I know that there are a lot of words on this slide, and I want to highlight that we just issued today, thank you Heidi, all of her hard work, a new bulletin that really goes more into depth on the changes that have happened with the notice of hearings. Major changes including if the relatives responded to an agency's relative search notice and kept their contact information updated with the court, they must receive notice of post-permanency review hearings, regardless of whether indicating they were willing to be an adoptive resource for children. If they were previously ruled out by the court as suitable foster parents, this no longer affects their ability to receive this notice. However, there still is an exception if the court previously ruled them out as a permanency resource, and I will highlight that the court has previously ruled them out. If your agency has ruled them out or determined them not to be a permanency resource, they would still get this notice. There is a difference between being ruled out by the court and being ruled out by your agency. Relatives may now also request and must be granted the notice and right to be heard. So that right to be heard is a change in any review hearing held with respect to a child, regardless of whether they are providing care for them. Relatives can also now regain the right to receive notice of the possibility of permanent placement and permanency progress review hearings when they provide a current address to the agency and the court. So we're really just trying to keep these relatives informed. For the permanency notice, there's also been some exciting changes. The responsible social service agency no longer has an ability to ask the court to modify or relieve them of the requirement to send the permanency notice to relatives. There is also no longer an automatic waiver of this requirement if children are placed in family foster homes committed to being permanency resources. And if relatives fail to respond or do not respond in a timely manner to that permanency notice, it cannot be used as a basis to rule out relatives from being permanency resources for children if they want to be considered for permanency later. And some of the reason behind this change is we're really trying to ensure that relatives have an opportunity for possible permanency placement sooner than later, wanting to not delay permanency when relatives they'll get the APA notification, the adoptive placement agreement notification, and then trying to delay or lessen some of the contested adoptions. It didn't really make sense that we weren't sending this permanency notice sooner and then relatives later getting the adoptive placement agreement notification. So we're really trying to just keep relatives informed sooner with this permanency notice requirement change. It also allows relatives to change their minds. And so if for whatever reason, maybe they indicated that they weren't interested and now they are, this permanency notice gives them an opportunity to change their minds and to let the agency know that they are in fact a permanency option later on. And again, there was a lot of information and we'll post that link to the new bulletin that is really helpful with some of the changes with the notice requirements. For adoption considerations, there are more reasonable efforts that we have to make to finalize an adoption, but these are specific to relative search and our purpose today. So our efforts to finalize are including updating that relative search, giving notice of the need for an adoptive home to relatives who have kept the agency or court informed of their whereabouts or newly located relatives. And again, continuing to engage relatives to commit to being the adoptive home. There may also be times where an updated relative search is required. And that is if the child or youth, there is no adoptive home, regardless of the court relieving agency of the relative search efforts initially. If the child has been removed from the pre-adoptive home, or if the court determines that an updated relative search is in the child's best interest. For adoptive placement decisions, there's been a change that we are also now making these decisions based on children's current needs and future needs. Relatives considered for adoptive placement according to the specified order prior to considering non-relative families. Also, County Social Service Agency adoption records must include agency's consideration of relatives for the adoptive placement, and then following that specified order. Workers are able to document those efforts in the children's out-of-home placement plan or part of the adoption placement decision summary. For relatives that may become known to the social service agency after an adoptive placement agreement was fully executed, your agency may refer those relatives to a private licensed child placing agency for an adoption home study through PPAI. If the relatives are interested in being considered as an adoptive resource and believe the agency was unreasonable in not making adoptive placement with them, your agency must inform them of the process for filing a motion for adoptive placement. And there has been a change of filing that motion that we'll talk about later on. This is also the same information that we provide relatives when or if they contact us at DHS. We also provide them the information. So if your agency is also providing it and just making them aware of what their right is to file that motion. If relatives become known to agency staff after the adoptive placement agreement has been fully executed, the agency does not need to send relative search notice to newly identified relatives, but you still may want to engage them or refer them to get an adoption home study depending on what they are stating they want to be involved in. For the adoptive placement notification, so once you have that fully executed adoptive placement agreement and you filed it, there's the APA notification, and there has been change to the filing requirements. The approved adoption home study is no longer required to be in place when relatives or foster parents file motion for adoptive placement of children under guardianship of the commissioner. If a relative does not have an approved adoption home study in place, they must be working with a county, tribal, or private licensed child placing agency to obtain an approved adoption home study. Agency staff signing the affidavit is verifying that the relative is working toward completing adoption home study per the agency requirements. So that's the change. Since the family doesn't have to have an approved adoption home study, they need this affidavit stating that they are working with an agency completing the home study requirements. The agency completing the home study determines the circumstances under which they will sign the affidavit attesting to the moving party's efforts to complete the adoption home study. It's important to point out that we are not defining what the efforts to complete an adoption home study means for the purpose of filing an affidavit. It will be up to that agency who is working with that family to determine whether or not they will sign that affidavit and if it meets their requirements that they are working towards completing an adoption home study. And with that, I will pass it off to Ashley Holmes.
Yes, good afternoon, everyone. Okay, what is the ICPC? The Interstate Compact on Placement of Children is a mechanism that we have to ensure protection and services to children who are placed across state lines for foster care, adoption, parental, relative, and residential placements, and also group homes. The compact is a uniform law that has been enacted by all 50 states, the District of Columbia, and the US Virgin Islands. It establishes orderly procedures for the interstate placement of children and fixes responsibilities for those involved in placing the child. The ICPC also ensures that these children receive the same protections guaranteed to the children placed in care within Minnesota, meaning that the law offers states uniform guidelines and procedures to ensure that the placement of these children take place in ways that promote the best interest of children. I should note that the ICPC does not cover placement or process when looking to move a child outside of the United States. And agencies can make requests so at the point of an agency gaining care custody of a child, they can make a request right away, right at the EPC time that they take custody. And also, they can make more than one request at a time. So if you have multiple relatives or individuals outside of Minnesota who are looking, that you're looking to possibly place a child with, you can make multiple requests at a time. And also the emergency placement does not exist in the ICPC compact. And the quickest type of placement is an expedited Regulation 7. Okay. So when does the ICPC apply? So the placement of a child in the care or custody of a state public child welfare agency with a relative family, a foster family, or an adoptive family, or when a placement of a child by any individual or entity to another state if the placement is for the purpose of adoption. So ICPC does see private adoption requests from all over the US. And the placement of a child by any individual or entity into a licensed residential treatment center located in another state. So we receive those from agencies and also parents that choose to place their own children into residentials in another state. And under certain circumstances, the placement of a child with a child's parents located in another state. I want to note that ICPC is not, you do not need to invoke ICPC if you are going to have a child go to another state for a visit that's going to be 30 days or less. Or also if it's during a child's natural educational break, such as summer vacation, and it's just a visit. And Regulation 9 of the ICPC gets into the definition of what a visit is. And also an ICPC is not needed. I get this question quite often. I would say actually probably weekly, but ICPC is not needed when a child is going to move to a parent for whom the child was not removed. If all of the following all line up. When the court places a child with a parent from whom the child was not removed and the court has no evidence that the parent is unfit, does not seek any evidence from the receiving state that the parent is fit or unfit, and the court relinquishes jurisdiction over the child immediately upon placement with the parent. The receiving state shall have no responsibility for supervision or monitoring of for the court having made that placement. Okay, next slide. So emergency placements, there are additional ICPC regulations that cover other types of out-of-state placements, but for the purpose of today, I'm just going to focus on the Reg 7, also known as the expedited request, due to this regulation requiring that specific findings be made by the court prior to the agency submitting an ICPC request packet. And as I noted a little bit ago, the ICPC does not have any regulations that allow for an emergency type of placement to occur. So the quickest type of request that can be made with a decision made by the receiving state is embedded in Regulation 7. And this type of request is only for a parent or a relative unlicensed home study, not for foster care licensing or adoptions. And I don't there's several times that children are placed out of state into a relative unlicensed home that is approved. And in that situation, then we would also follow up for that home to become foster care licensed. So I don't want, so ultimately we would want a home to become foster care licensed or adoption approved, but we can still place kids over state lines into an unlicensed relative home. And in order to do a Reg 7, the child will need to meet one of 4 criteria, plus the child has to have a specific relationship to the resource whom we're requesting them to be placed with. Next slide. So as far as that relationship, so Regulation 7 specifically indicates that it could be a parent, step-parent, grandparent, adult uncle or aunt, adult brother or sister, or child's guardian. I have seen some agencies submit requests where it is a great uncle to the child, and I will typically will accept that in Minnesota and process it, but the other state, because it's not a direct uncle or aunt to the child, then some other states may void that from being a Reg 7. So just be aware that even if it's a second aunt to the child, or it's a great aunt, that another state may not accept it because it doesn't fit into the exact definition. I'm sorry. So cases involving a child who are under the jurisdiction of a court as a result of action taken by the child welfare agency, the court has the authority to determine custody and placement of the child, or has delegated such authority to the child welfare agency. The child is no longer in the home of the parent from whom the child was removed, and the child is being considered for placement in another state with one of those individuals that I listed: parent, step-parent, grandparent, adult uncle or aunt, adult brother or sister, or child's guardian. And then for the other criteria, so one of the children in the sibling group would need to meet one of those criteria: that there's an unexpected dependency due to the sudden or recent incarceration, incapacitation, or death of a parent or guardian. And incapacitation means a parent or guardian is unable to care for a child due to a medical, mental, or physical condition of the parent or the guardian. Or 2, the child sought to be placed is 4 years of age or younger, including older siblings sought to be placed with the same proposed placement resource. Or 3, the court finds that any child in the sibling group sought to be placed has a substantial relationship with that proposed placement resource. And substantial relationship for ICPC purposes means that the proposed placement has a familial or mentoring role with the child and has spent more than cursory time with the child and has established more than a minimal bond with the child. Or 4, the child is currently in an emergency placement. So as long as one of the children in a sibling group, or the one child, it meets one of these 4 criteria, and the placement resource is one of the individuals listed on the last slide, then your court could make a Regulation 7 expedited order. Okay, next slide. So one important thing about expedited requests is they're super time sensitive. So I have listed out what the regulation actually says, and then so we'll kind of go through that. So basically the judge's signature on the expedited order is what triggers the time frame. So if the judge signs an order on October 1st, that is the start of how the rest of the process plays out. Within 2 business days of the hearing or the judge's signature, the expedited order shall be sent to the agency. Then within 3 business days of the receipt of the order, your agency shall send a complete ICPC request to the Minnesota ICPC office. And then Minnesota ICPC office has 2 business days after the receipt of a complete request from the agency to get it to the other state office. And I just want to note, when I do trainings at counties and we talk about this, I know that's a lot of 2-day, 3-day stuff. And I tell agency workers to just kind of focus on making sure that Minnesota ICPC gets that complete request no more than 5 business days from when the judge signs it. So whether the court gets it to you within 1 business day or 3 business days, that's not going to affect, what the other state sees. But as long as you get it to Minnesota ICPC within 5 business days, so it gives us that 2 business days to get it to the other state. And if we do get it to them, let's just say business day 8, it has happened and they could void out that Reg 7 order and just process it as a regular Reg 2. And then once the other state does receive it, Regulation 7 says that no later than 20 business days from the date that the receiving state ICPC office receives the complete request, that they shall render an expedited placement decision. There is information in Reg 7 that there's, could be situations that why a receiving state doesn't provide that decision within the 20 days. They could have concerns about something flagged on a background, or they were unable to meet, like schedules didn't match up with the grandparents and the resource. So there is sometimes we do receive request or the final home study and decision past the 20 days, but there needs to be a valid reason, and we need to be provided that status at least by 20 days from that receiving state. And then I also want to mention provisional decision. So this is something that your judge could also check in the court order of wanting a provisional decision. Reg 7 indicates that a provisional decision should, if a receiving state is able to render that decision, could be within 7 calendar days, but they don't technically need to honor that. There is some states, Texas and South Dakota, that don't ever provide provisional decisions, but then I'll see it from Nebraska and Iowa quite regularly. So each state's a little bit different, but a provisional decision is basically, if your judge were to check that, or a county attorney on that court order, what the receiving agency is doing is basically just doing a physical walkthrough of that placement resources home in the other state, assessing the home for any risks and appropriateness for placement of the child. They're searching that state's child protection service database for any prior reports or investigations on the prospective placement, and performing a local criminal background check on that prospective placement. And then next slide, please. Just some implications of not using the ICPC, just to kind of be aware of, is when a child is placed out of state without following the ICPC, home assessments usually haven't been done yet, and follow-up supports and services have not been arranged. And this can set up the possibility of children being placed at physical and emotional risk without adequate services. When compact law is followed and the receiving state approves a home, the receiving state is obligated to provide supervision on request. And also, when children are placed interstate without the ICPC approval, often the new caregiver is unable to enroll the child in school, and may not be able to obtain a medical card, especially for those 4E kids who would be automatically eligible for medical assistance if that home was approved. As a result, a placement with the proper services could become a permanent home, but may unnecessarily disrupt, causing more trauma to the child and yet another move or delay in permanency. If a child is placed prior to sending an ICPC request and receiving ICPC approval, a receiving state could choose to refuse to accept or process that ICPC request, and could even ask that the child return to Minnesota before they accept that request or do a home study. Ultimately, I see what we would call these violations when children are placed over state lines without the appropriate approval, but we can work to get into compliance. I mean, each state and situation is very different, but in general, I probably have these conversations once a week as well. But I talk to workers about, if a decision was made by their court or agency to move a child for whatever that reason was, I always tell workers, follow up with that ICPC request right away, and in the cover letter detailing why they placed in violation of ICPC, how they determine that home to be safe and appropriate, and why it's determined to be in the child's best interest. And many times a receiving state may accept it, process it, get it out to their local agency for a home study, but just know that oftentimes that when children are placed out of state without the approval, another state is not going to assign for courtesy monthly supervision. So that would still be on you. And like I said, with the medical piece, if they're a 4E eligible child, they will not be automatically added. Okay, and with that, I will turn it, I think, back over to Alicia.
All right, thank you. Actually, I was gonna go next. Ashley, thank you.
Sorry about that.
That's all right. So here we're gonna talk about the court review of relative searches. Let's see. So Minnesota Statute 260C 221 requires that no later than 3 months after the child is placed in foster care, the juvenile court reviews the agency's due diligence in exercising reasonable or active efforts to identify any maternal and paternal relatives of the child, and to engage these relatives in providing support for the child and family, and documenting that relatives were provided a notice as required under subdivision 2 of that statute. And the idea of due diligence is not new, as it has always been in federal guidance for a while. Agency have always been required to exercise due diligence when it comes to relative search efforts. So I want to make sure I noted that. Part of this review is that the court will also review the agency's decision regarding placing a child with the relative. So if the agency decides that the relative placement is not in the child's best interest at the time of the hearing, they'll be required to inform the court, including why the agency decided against that relative placement, and also the agency's efforts to engage relatives to support family connections for the child in the care and planning. One of the new amendments to 260C.152 subdivision 5 now clarifies that relatives have a right rather than opportunity to be heard in any review or hearing to be held with respect to the child. And this is regardless of whether they are currently providing care to the child, but that this does not require a relative to be made a party to the proceeding based solely on that right. So just want to make sure that's one of the changes to that amendment, that it changed it from relatives have a right rather than opportunity. Next slide. So some of the review elements to meet the court provisions under 260C.193, the court will review and enter findings regarding a wide variety of things. However, we are highlighting or addressing the review elements related to relative search. So like I mentioned earlier, no later than 3 months after the child is ordered removed from care of a parent in the hearing required under section 260C.202, the court reviews and enters finding regarding on whether the agency exercised due diligence to identify, search for, notify, and engage relatives, and that the placement is consistent with the best interests of the child. And also based just on that individualized determination of the child's needs to select a home that would then meet those specific needs. 260C.193 now also clarifies that the court shall order the agency to make reasonable efforts if the court finds the agency has not exercised due diligence. So if there's a relative who qualifies to be licensed to provide family foster care under 245A, the court may order the child to be placed with a relative consistent with the child's best interest as well. So even though the courts find that agency's efforts to identify and notify relatives were sufficient, the courts should order the agency to continue to appropriately engage relatives who respond to these notices in placement and case planning decisions, and to appropriately engage relatives who subsequently come to the agency's attention at any time. So if a court's finding of an agency's reasonable efforts does not relieve the agency of the duty to continue notifying relatives who come to their attention and engaging and considering these relatives as well who respond to the notice in the child's placement and case planning decisions. The statute section also now clarifies that the court, and we mentioned this earlier, cannot waive relative search notice and consideration requirements in its entirety. So outside of the safe place for newborn cases. Though if a parent requests that a specific relative not be considered for placement, the court can honor that request when it is in the best interest of the child, which will be consistent with 260C 221. So if the child's birth parent expresses preference, placing a child in a foster or adoptive home of the same or similar religious background as that of the child or parent, or parents, the court shall order placement of that child with an individual who meets the birth parent's religious preference. I believe Jessica mentioned this as well in an earlier slide. And section G of this statute also requires that siblings do be to be placed together whenever possible in foster care rather than expressing a preference for joint sibling placement. And clarifies that siblings may be separated if this joint placement is not in the best interest of one or more of the siblings rather than all the siblings. So this requires that agencies consider the foster care sibling bill of rights in making this determination as well. If siblings were not placed together to begin with, the agency should be reporting report to the courts the efforts they made to place the siblings together and why those efforts were not successful at that time. If the court does find that is not satisfied that the agency has made reasonable efforts to place siblings together, the court may order the agency, must order the agency to make further reasonable efforts. If siblings are not placed together, the court shall order the responsible agency to implement the plan for visitation among those specific siblings. And this is also required as part of the out-of-home placement plan as well. And this subdivision 5 does not affect the ICWA as well or MEFBA as well. So next slide. So just wanted to make sure we put up a slide here that kind of outlines the helpful questions for judges. Since there's no uniform form for submitting relative search reports, we just wanted to provide here some helpful questions that judges may ask when reviewing who has been notified, engaged with of the relatives and placement with the best relative. So for example, asking what methods have been used to identify and locate potential relatives will be helpful. It's not just enough to just ask parents. So this will identify other avenues used as well by the agency in the review process. Another helpful question, how has these relatives been engaged? So getting to understand the contact method that were used would be important to keep in mind that mail can be unreliable sometimes. And due to language barriers or reading levels, letters may not be effective, as many cultures are just more oral anyway. So it will be important to make sure that you're using different kinds of contact methods as well. So part of how, questioning our relatives were engaged could be what were the efforts to engage for possible placement and also for participation in case planning. So not if they are involved, but how were they involved is the kind of question that's being asked here, and what can they offer to the child. Also, what may be helpful to ask is if maternal, paternal relatives were pursued with similar vigor. So we often see that maternal families are pursued a little bit more. Often, paternal families are pursued with much more effort, even when they might be relatives that are able to meet the child's needs on the paternal side. So it's really important when we go back to that slide about engaging possible fathers to make sure that that side of the child's family is also pursued with as much vigor as the maternal side. Another example of a question that judges may ask would be, are there out-of-state relatives that may be an option for this child care? If has an ICPC referral been submitted? Keep in mind, like Ashley just got done talking about, that ICPC can take a long time, so agencies cannot wait to submit ICPC. Sooner is better. Next slide. So in this section, there are just some potential orders from the courts after reviewing a relative search. So if the court finds that the agency did not make proper efforts, they may order agency to continue the search, to search, notify, and consider relatives, and engage and consider relatives. So if a relative is available who qualifies to be licensed to provide child foster care, the court may also order that the child be placed with a relative consistent with the child's best interest as well. If the court is satisfied that an agency has exercised due diligence, the court may find that an agency has made reasonable efforts to conduct a relative search to identify and properly notify relatives. The court must order the agency to continue to engage relatives who responded to the notice, as well as relatives who come to the agency's attention at a later date. For American Indian children, the court must find that agency has made active efforts to conduct a relative search and to notify relatives as well. Lastly, at any time during the juvenile protection proceedings, the court may order an agency to reopen its relative search when it is in the child's best interest as well. Jessica will now walk us through the SSIS relative search screens.
Hello, I'm going to just pick up and talk a little bit about the new relative search screens that were new in the last year. So I'll tell you where they came from. As part of the FFPSA requirement to document the family and permanency teams, we needed to build a new screen in SSIS for recording relatives. While we were doing that, we wanted to make sure that it could be helpful beyond just family and permanency teams, and might be one way that an agency would be interested in documenting the relative search efforts. So it is not required to be used. We recognize that some agencies have different programs that they've built or specific formats that they fill out and use, and that is perfectly acceptable. And so I just want to be clear, this is not required, but it is one option that we wanted to make available. So just, I'm super high level looking at what does this look like. We did put this under the permanency node. So it's in the, the person folder. One of the reasons we did that is that if it is documented here in a previous case, and for some reason later the child comes back into care, it would be easier to locate there as opposed to being embedded into the previous work group. So I did want to say that it is under the child's in the tree, their permanency node, where the placements are usually located. So with that, we have just a general overall, you can have multiple different searches, the date that the search started. We did leave them all with parent 1, 2, 3, and 4, recognizing that there might be more than 2 parents, and there might, particularly if there is an alleged father, SSIS does allow there to be, when you put in a father, you can denote that it is alleged so that it isn't, locked permanently as a father if that is later determined not to be the case. And then this is what the screen just looks like. We tried to leave it as open as possible, knowing that even as you're getting information from relatives, it may, or from any person who provides information, it might not be complete. And so there are ways to pull in existing relatives that are known or are in the SSIS system. There are ways to just enter in a new person, a partial name, and wanted to, through that, look at through the lineage or connection, being able to do, make sure, I saw a question there earlier of what to do if there's multiple alleged fathers. This screen does allow for that. If you identify parent, 2, 3, and 4 as 3 different alleged fathers, you can note which relatives apply to which alleged father. And then information just in following up on that, again, coming back to, it's not just about placement. This could be used outside of a placement case. This could be used as part of the prevention to placement and pulling in supports around a child in an easy way to record information, contact information for reaching out and being involved in some sort of family group decision making or supporting them to help prevent placement. So that's why we have it first contacted about participating in case planning in those instances where there might be a need for foster care or permanency, and those timeframes would be different, allowing that those all can be updated, and you may have some of this information and not all at once. So just wanted to give a high level overview that this does now exist in SSIS. There is on the, where this webinar is going to be placed is on the Minnesota Child Welfare Training Academy webpage under the FFPSA. That we already have a number of webinars, including one on this relative search screen and some guides. That's where we will put the slides for this, any questions that we end up following up with after the fact. And when the recording is available, it will be available there, recognizing that we were planning to have that there no matter what, but unfortunately ran into a situation where we had more than 300 people try to log in, and there was apparently a limit. So I just want to let you know that this recording will be available in its entirety on that page with those other documents. And you can also find previous information there. I do want to say that these questions here match kind of our previous format from our EDOC 3799, which is the relative search letter. That is currently in the process of being updated. We were hoping the new version would be live as of today. It is not yet live, so coming soon, hopefully in the next week or so, will be the updated one with any of like the statutory citations or pulling in new information that is now required because of the legislative changes. So that EDOC will automatically update when the new version is published. And with that, I will turn it back over to Tendai.
All right, thanks, Jessica. Just a few things to keep in mind that are upcoming. We will be publishing a relative search notice, engagement, and consideration practice guide, and that will be soon. And this will include all the new changes you have heard today. I think there was a bulletin about relative search, but now we actually just going to be doing a practice guide on that, and we're hoping that this will be published soon as well. So be on the lookout for that. We will be sending a Gov delivery or a bulletin to announce it as well when it's ready. And another upcoming is the kinship website contact list. We are currently working on creating a kinship contact list that relatives would use to contact the county or tribal worker when they have questions. This will eventually be housed on our foster care county link website. So when it is live, we'll send out a Gov delivery about that as well. So you can notify relatives or anybody who would be interested in seeing that list and who would need to be contacting county workers with questions about kinship. So next slide. All right, that is the end of our presentation, and we're going to try now to get through the questions that we're seeing here or that were asked in the presentation. And I'm hoping that as we answer the questions, we're going to make sure that we also capture the questions, and then we'll do a Q&A that's going to also be published on when this recording is provided to everyone, and also the PowerPoint. So all those documents in the recording of this webinar will be available for later viewing as well. All right. Let me see here. So a few questions that we were able to kind of capture in the beginning here. There's actually a few questions about ICPC. Ashley, I wasn't sure if you want to kind of just walk through those. Does regarding ICPC, does this apply to custodial parents who moved out of state during the child protection proceeding and are working towards reunification, and there's a trial home visit ordered by the courts?
So yes, so anytime that an agency has care, custody, or there's court jurisdiction, we do need to send an ICPC and receive approval before a child moves over state lines. But I do want to mention, and I know this wasn't in one of the slides, there's something called a Regulation 1, where it's an intact family. So if a child is reunified with a parent or placed with a relative in Minnesota who's maybe not licensed yet, so they're unlicensed, or maybe they are licensed, or maybe they're already approved for adoption, and they, for some reason, that individual parent or relative were to get a job in another state, the child, since it's an intact family, meaning that the child was placed or moved with them while they're in the state of Minnesota, then that's kind of the one exception where the child can then move over state lines with them before the ICPC request packet is sent. And it, like I said, it falls under the Regulation 1. And if anybody has any questions about that, I can provide what that language actually reads. But as far as the actual question, even if it is the removal parent and they move over state lines for whatever reason and the child hasn't been reunified or moved with them yet, we do need to send a parent home study request to the other state for them to do a parent home study and give approval before the child is moved, in compliance with what the ICPC regulations and articles say.
All right, thanks, Ashley.
And Sarah Nelson, no, sorry. I said there's
Go
no
ahead.
currently process for other countries, and that is correct. There's not a compact, an agreement, or MOU or anything like that between other countries. Puerto Rico is not part of the compact, but they, I can't think of the exact language, but they do accept ICPC requests. They do send them. They just don't have it in their own laws yet. I could definitely see that coming in the coming years as they're working to become a member to the compact. But as far as Canada, I know some of the guidance we've provided before that Canada doesn't accept ICPC requests. They don't have like an ICPC office or anything like that. But when it's out of country, the direction we've kind of given agencies before is that although it won't go through the ICPC, they can try to contract directly with private agencies. And there is some agencies who have multiple work in multiple countries that can provide home studies and provide the same service such as the courtesy supervision. But it just doesn't go through the compact because they aren't a member to the compact.
I'm going to jump in and also add that a great resource with children who have parents in another country is contacting their consulate and seeing if you can work with them. Certainly here in Minnesota, we have the Mexican consulate in St. Paul, and they are very helpful in that process. But there are some private agencies that do that internationally, but also sometimes the consulates can arrange with their social service agencies internally in the country to do that.
All right, thanks, Jessica. I believe there was a question that asked, do we do a relative search for biological dad or legal dad if we know legal dad isn't biological? If we have a variety of possible fathers, do we search our relatives of possible dads? And this goes back to the slide that we talked about earlier on making sure we engage all possible examples of fathers that may be involved. And in this case, if the child is has a relationship with both the biological father and the legal dad, then it would, I think, best practice would be to make sure we're doing relative searches for all those possible dads involved for that child's best interest as well.
I would just add that, of course, that's always a consultation with your county attorney on how to work through that and bringing any questions in front of the court as necessary. We definitely, from a best practice standpoint, don't want to leave out a father and his family and then have that be, very late in the case and a lot of decisions being made where they haven't had the opportunity to be considered.
We have a few questions about, similar questions about, is it the agency's obligation to keep the court updated with relatives' contact information, or should the relative be contacting the courts?
If the agency has the information, they should be providing that to the courts. And if there's any specific questions around how that all works, we can work with our CJI contacts, the Children's Justice Initiative, on the best way to do that and provide that in our Q&A. I know previously we've asked if a relative just called into the court, would the court administration be able to provide information? And they said they're unable to confirm or deny a case, and that the relative would likely need to already have the case file number, which would be a concern because most people are unlikely to be able to have access to that already.
There's a question, if there's no adoptive home, when is the updated relative search required?
That was my question. Can I clarify a little bit?
Sure.
So I guess I was thinking like, for kiddos who are wards of the state, of course you would want to do that updated relative search like right away at the beginning if there's no adoptive home, but say they end up being wards of the state for, months or years. Is there like every certain amount of time, like every few months or every year, or like, is there a requirement there?
Says Alicia, and maybe Heidi or Tendai, statute doesn't specifically state a requirement of how often. You would just continue to be updating it or wanting to be relooking at it as your agency kind of determines, or working with the PPAI for child-specific recruitment, but it would all just revolve around your agency making reasonable efforts and doing due diligence throughout trying to identify and continue to locate a permanency resource.
All right, thanks, Alicia. Let's see here. I know Jessica mentioned that if we don't get to all the questions, we will be having a Q&A with all the questions that are currently in the chat, to make sure that all the questions are answered in that way as well. So we have somebody asking if they can unmute to ask a question. Go ahead, Binta.
Thank you. Thank you for the great information. Can you hear me? It's kind of low here.
Yes.
Can you hear me? Sorry. Okay. What is the requirement? So if a grandparent has TLC, transfer of legal custody of his or her grandchild, what is the requirement? What needs to happen for the family or the grandmom or grandparent to lose the TLC? Did I lose you? Hello?
Oh, no, we're still here.
Okay. Should I ask the question again?
So I guess I'm wondering, are you thinking within a child protection process or outside of a new CHIPS petition?
Yeah, within the child protection process. So if a grandma has TLC of a child, and if grandparent allowed the child to visit his or her mother and the other siblings, can the grandparent lose that right? Can it be brought to court because they allow mom to visit with the other sibling?
So this is Alicia. I would say that you would need to consult with your county attorney. We can't give legal advice since jurisdiction, the transfer of permanent physical legal custody has been transferred to the grandparent. So if you receive more information as far as contact or something that may, like child maltreatment and a new child protection potential intake, you would go through that process. You'd have to consult with your county attorney and then address those concerns and issues internally as an agency. And Jessica and or Heidi might have, but we can't really give legal advice. So I would have to defer you back to your county attorney if you had concerns post finalization.
Yeah, okay. Now I think I was asking more in terms of education around the TLC. I don't know if it was mentioned here. I heard about the TPR in adoption. But for the TLC, I don't think I hear. Maybe I missed it. That's what I'm asking. Maybe I'm more specific.
I would encourage you, we have our contact information. If you have a specific situation, send us an email and we would be happy to follow up specific about that. But today's purpose was more around relative search, engagement, and notification, and not post finalization.
Thank you so much.
Thank you, Binta. There was another question here about placement considerations, Jessica. So if one child is with a relative and another is not, keeping them together does not take precedence over best interests for them to be apart?
So that's where a lot of things come into play. We said there's a number of different things that kind of come together in placement decisions, and that as pointed out in like the sibling bill of rights, it also states that if it is, I don't have the exact language in front of me right now, but if it's contrary to the best interests of any of the siblings, it doesn't have to be as a whole. So that's really coming back to always, we're going to emphasize the individualized determination, and the sibling relationship is both one of the listed best interest factors, and we also have the sibling bill of rights, and that interplays with all of the stuff and options that you have, including if there's like a parental religious preference. And the update says, according with the new legislation, one of the things that we talked about today also is that it's not any one factor to the exclusion of all others, so that it is a complicated interplay of how they all work together. So I'm sorry I don't have a straight answer for that. We would always encourage teaming with multiple people within the agency, discussing with your county attorneys, and at times if it determined that it would be appropriate, we can either pull together a consultation with other people in DHS to help you think through things as well.
All right, thanks, Jessica. Let's see here.
And just apologize as we're a little slow scrolling through. We were keeping a list of ones we knew we hadn't answered in the chat, and others that we had, and trying to kind of keep them cohesively in what we're answering and see what's been answered and not. So apologize for a little bit of the delays. I am going to take one that I'm not sure we answered. I saw it come in during the ICPC section of if a child is in foster care, wondering about a 72-hour limit on how long they can be out of a licensed home, but that they can go out of state for a visit for up to 30 days. there's a lot of different kind of timeframes that play into that. I would say one of them being like the 72 hours that I think of more is that as part of the prudent parenting standard, a family foster home or facility within making decisions consistent with the child's prudent parenting and opportunities to participate in normalcy can authorize up to 3 overnights out of the foster home. There's a 14-day limit on time that a child can be out of the home and the foster home still, if they're, were in that home, went somewhere else for 14 days and returned back, and it was a planned visit or vacation or something, that foster home can still be paid for up to those 14 consecutive days if the child is returning back into that same home. And then there's kind of the ICPC regulation of when you would need it or not. So a lot of that is actually a case planning decision of what really meets the child's best interests. Certainly an agency can decide that something more than 72 hours is appropriate for a child to be out of their foster home. If that's, for a lot of different reasons, they might have things going on. And then if you have questions about that, again, going back to the supervisor or county attorneys, and I know some agencies would bring that in front of the court and others may feel that they're able to make that decision there. So it depends, and they don't always play nicely in the different sections of when things were passed and what they're intended to address. So clear as mud, but ultimately a lot of it comes back to a case planning decision.
Related to that, it looks like Liza asked if DHS has a bulletin on like the 72-hour prudent parenting or how long kiddos can be out of a licensed home.
We have a couple different documents that I can think of, and I'll pull them up and put them in the chat. We do have the prudent parenting e-doc, so the policy guidance on that. We also have the one that is, I think, 7830A, which is using alternative care arrangements for children that are in foster care. And so those are the first two that I'm thinking of that I'll make sure to get to you.
And this is Heidi. I just also am seeing Sarah had asked a couple of questions wanting to make sure that they were addressed. And I can talk about that first one that Sarah asked, which is if agencies have to continue to submit relative search reports to the court after a TPR and until the adoption is finalized. And to that goes along with the court's review of agencies' efforts to reasonable efforts to finalize an adoption of a child. And so one of those reasonable efforts does relate to the relative search. And if you had reopened the relative search, whether through court order or through the agency's own volition, then reporting on what happened with that would be considered a reasonable effort towards finalizing a child's adoption, anything around recruitment, et cetera. So it goes along with those reasonable efforts to finalize the adoption. And then I don't know if you guys want to address the next couple of questions about wanting clarification if agencies can be relieved of identifying or searching for relatives, but cannot be relieved of engaging relatives and notifying relatives who come forward at a later date. Anybody wants to talk on that from that foster care perspective?
All right, thanks, Heidi. So yes, so when the court makes that order for an agency, that an agency has satisfied the relative search, this doesn't mean that the agency has been relieved of all efforts with relatives. So it's just that the agency is not required to continue to actively search for relatives. However, if a relative who responded becomes known at a later time, it will still need to be notified and engaged and considered as well. Jessica, would you add something to that?
No, because I'm answering other questions in chat.
Thank you. All right, we have about 6 minutes left, and I am thinking in order to not rush through answering questions, we may just close up and end here. But like we mentioned earlier, we are pulling all the questions, even the ones we just answered today, and we will be providing them in a Q&A. So when we post the recording of this webinar and the PowerPoint presentation, there will also be a Q&A available with all the questions that's been asked today, so that everything is available to you to review at a later time. My understanding is that the recording may take a day or two to be up and running, so give it some time. And I know Jessica did post the link to where the recording is going to be provided. I believe we may send out a Gov delivery to everyone like we did for to announce this presentation, to just let everybody know that the recording of the relative surf and engagement training is also available, including accompanying documents. So we'll be able to do that as well. Jessica, you can go to the next slide. So thank you very much for attending. I know we had a little glitch there with max attendance for people, but we're glad that we had 300 people who attended today. This is for if you have follow-up questions today or tomorrow or moving forward on anything to do with relative search and placement, placement decisions and case planning, you can definitely email us at that foster care email. Questions on adoption and kinship policy, you can email the North Star Benefits email, and then ICPC, you can email that ICBC email there as well. So please let us know whenever you have a question, email us, but we appreciate your time today and thank you very much.